Justice and some of the intersections. I'm your entertainer for the afternoon again. Um, and today we're gonna hear about, in this first panel, about one of the trickiest intersections that we are facing today at the various levels internationally and locally, which is abortion and disability. And it's a key issue to take on head on from a feminist perspective for various reasons. One of the reasons is that it really challenges the way in which eugenics have also a legacy within the feminist movements, and we haven't really confronted it. Another issue is that fundamentalisms and right-wing and religious groups have used disability as a way to further an agenda of criminalizing abortion in different parts of the world. And another reason is that there are currently several tensions at the international standard-setting bodies that have divergent issues with the way the human rights standards on abortion should be set. So there have been some tensions between the Human Rights Committee and the CRPD committee and the CEDAW committee, and those conversations are happening and being facilitated there. So as civil society, we do have the opportunity to bring about the issues that are that we are facing in our struggles, and that are the reality for many women. Because sometimes we lose sight that our main goal is that actually people can make their rights effective in their daily lives. And many times we get entangled in how standards, laws, and policies are set and forget to think about the actual realities of people. So without further ado, I want to first pass the mic to Stephanie Ortoleva, President and founder of Women Enabled International, to start us in the conversation.
Thank you very much, Andrea, and welcome everyone this afternoon. So, as Andrea said, I'm the President and Executive Director of Women Enabled International. And we work at the intersection of women's rights and disability rights to advance all women, but with a special focus on women with disabilities. And we engage in a variety of collaborative projects with partners in the women's rights and disability rights or disabled women's rights community around the world, with the objective of trying to do cross-cutting advocacy and work between the movements. And we have as our primary objective to strengthen the human rights standards on the international and regional level as they relate especially to women and girls with disabilities and our lived experiences. So I agreed to do this panel and this presentation. We've done it I've done it one other time. And what I find so interesting about this particular issue is that I think it can be a really helpful way of bridging and establishing communications between disabled women and non-disabled women on a critical issue of importance to us. Women Enabled International, which we affectionately call WEI, so we don't have to say all those words, is beginning a process of doing a series of consultations, because in our experience, we have found that often the voices of disabled women are not heard and part of these debates. Although I know there were activists here in Ireland around the issue, which is wonderful news. There are also some activists in Poland who have been very, very public, but mostly the disabled women aren't consulted. So we're in the process of framing an intersectional analysis for this issue. So I'm just highlighting some of the key issues we're focusing. So there is this perceived conflict between abortion rights and disability rights, and I call it a perceived conflict. And often this is sprung from the issue of abortion access on the very limited ground of so-called fetal impairment. And I use the word impairment here throughout this conversation because I'm just drawing on a term as it's used in the treaty. And we're talking about a fetus, so we're not talking about a person. So this historical and political context, though, is really important for us to keep in mind. On one hand, restricting abortion laws in many countries has, as reported by the World Health Organization, resulted in increased maternal death and injury. And unfortunately, there is a very well-funded anti-abortion rights movement that sometimes actually mentions disability issues, but in fact, the only time they sometimes seem to be interested in disability issues when it surrounds the issue of abortion. They don't advocate, for example, for increased funding for inclusive education or other services.
They're restoring the captions. So maybe let's just play for a second.
Oh, captions.
Yeah, the screen went off.
Weren't we already, didn't we have this experience a few weeks ago?
Okay, now it's there.
Okay, is everything working now? Great. So in many countries right now, the only justification or the only reason one can have an abortion is based on so-called disability grounds. However, on the other hand, there's a very strong invaluing of disabled people, eugenics movements in the past, various stigmas and stereotypes around disability. So the governments very often will be regulating or allowing abortion on disability grounds, but doesn't allow for other funding for abortion-related issues. And very often there's a lot of stigmatized language, and that's an important concept in this whole discussion. So in some countries, for example, people have been very concerned because there's a dramatic decrease in the population of people with Down syndrome, Iceland, for example. So, but these debates must be reconciled because we all have a common and joint commitment to advancing human rights. And women with disabilities are also women who also may, in fact, need or want to have access to abortion services. So if you restrict one aspect of women's autonomy, especially in the area of reproductive rights, that has ramifications for other areas of sexual and reproductive health. So one of the core principles of human rights law, which I think really should unite the reproductive rights and the disability rights movement, is the concept of personal autonomy. So, and it's a strong value in both movements. It's core strong value in both movements. So the repercussions of this can have an attack on the autonomy of one person, can have a really strong implication for the autonomy of another. So an attack on the autonomy of women generally in reproductive rights can have implications for people with disabilities in other aspects of our lives as well. So autonomy is central to the concept of a life lived with dignity, and it's important for our ability to make decisions about our lives, and it's a root in our legal capacity. And indeed, a core concept of autonomy with respect to women is that we as women are the experts on our own lives and know what's best for us and our families. So we need to trust women on their decisions about their families. So in terms of denying disabled women autonomy in decision-making has often resulted in forced non-consensual sterilization, contraception, abortion, etc., without consent. So, or also issues about consenting to have sex and the right to consent to sex sexual lives and to have a family. So one of the ramifications of restrictions on abortion is that very often women end up then having to resort to illegal, unsafe, clandestine abortions or travel out of their own countries at great expense and risks to their health. So there's an interesting issue that's gone on in the abortion debate about selecting different types for different characteristics in terms of abortion. For example, people often point to prohibitions against sex-selective abortion in some aspects of some components of the feminist movement, although the main human rights jurisprudence hasn't taken that position. But there are other aspects of sex-selective abortion too. There's selections for traits. For example, there are some people in the disability rights movement who want to affirmatively select for certain disabilities in the deaf community or in other communities as well. So it's it's important to think about those components. So another important component, though, of the whole abortion debate is the right to access to fair and unbiased information. And it has to be evidence-based in order to inform your decisions. And we don't think it's rational for people to give women directive counseling when it comes to the question of abortion. So people should be given information they need, but not that it should be framed in a way which is suggesting one decision or another. And prenatal testing should be voluntary. Not all women wish to have prenatal testing. But people should have the option to have that testing and then to learn whatever comes out from prenatal testing, what it means for their individual pregnancy. And it's important to talk about issues of women's health, risks of miscarriage or stillbirth. And women also are not often given reliable information about parenting a child with a disability and what services are available to the family and the child in the local community. And that's a really important concept, the local community, because if people have to travel long distances in order to access services, that often means they're not going to access or be able to access them at all. And also, of course, people should be given information on where they can access abortion services if that's the decision they choose to make. It's important, of course, to train healthcare providers. That's an absolute essential in this entire debate, so that healthcare providers know how to give information to persons with disabilities, how to provide accessible information, and not to give directive information. And so there's also the whole issue of access of disability-related services for the family. The government has an obligation to do that, and that's a really important factor in this whole discussion. If governments don't provide appropriate services in the local community, that also influences the decisions that women would be making. And of course, if these services are not available at no cost in the community, that raises issues of the costs of raising a child with a disability in some circumstances. So there are also health implications for women that just go beyond the risks of miscarriage and other medical conditions like that. But we also need to consider the concept of health very broadly. It's a very complicated concept which has both social, cultural, and economic aspects to it. And some people have discussed the whole issue of the nature or the thought processes that goes on when someone has a fetal diagnosis, and basically that can also result in anxiety and concern because you don't know necessarily what's going to happen. And then the other issue that is very traumatic for some women is if a prenatal diagnosis indicates a medical condition where the fetus, when born, would die very quickly or experience severe pain, and that's another very and if there are also various medical procedures that are available to address some of the concerns, those might not be available in the woman's local community or even at an affordable rate that she could use. So the concept of discrimination has been used by the CRPD treaty bodies specifically, and I just wish to highlight the fact that in international human rights law, we think of the concept, we see the concept of discrimination as accruing to a person, and under current international human rights law, a fetus is not considered to be a person. So we can't really talk about discrimination against a fetus, although the CRPD committee has framed this issue more in terms of a sort of discriminatory environment for existing living persons with disabilities, and that's how they would see some of these laws around the world that regard so-called fetal impairment. And the other thing I just wanted to emphasize, which I think is very important in this whole discussion, is the terminology that's used. Many people use terms like, defective or abnormal, and those terms, that kind of terminology, does not really help in this debate at all. And we just have to try to work hard on using language that reflects respect for everyone. And the other just point I want to make is that we're doing this consultative project at Women Enabled International to basically bring in the voices of women and girls with disabilities to these discussions. If anyone is interested in discussing this further, I would really welcome that opportunity. And I think many of you have my contact information. I also have up here, hopefully at the end of the program, if you're interested, we have the flash drives for our accountability toolkit that I've mentioned before, and I also have some pens to give away as gifts to people. So please come and take those. Otherwise, I have to carry them all home. But thank you, everybody, and I hope this was helpful. I look forward to questions.
Thank you, Stephanie. The pens are purple, just so you know.
And the ink is purple.
And the ink is purple too. I think this brings several issues to keep thinking about. I think the question of prejudice and right to information. I've heard several mothers of children with Down syndrome remembering when the doctor told them about the prenatal diagnosis as if giving them condolences. So the way the prejudicial information is given, it's a key factor of right to information. And I think the question of personal autonomy as a core value is key. So now I would like to give the microphone to Siobhan Mullally, who is the director of the Irish Centre for Human Rights here in Galway.
Thank you for the opportunity to participate again and particularly to participate in this panel and to think about how intersectionality can inform how we think about and the kind of frameworks that we develop around reproductive justice, particularly in the context of disability. Of course, it's very timely at the moment in Ireland as we begin a process of legislating for access to safe and legal abortions, following the human rights movement that led to the repeal of the Eighth Amendment and that we have been discussing this morning. I'm going to think a little bit and just reflect a little very briefly on human rights law and law in its role in promoting, securing or perhaps denying reproductive justice. And law plays a critical role, as we know, in allocating the benefits of inclusion and membership and also in allocating the burdens of exclusion. And in Ireland, the Eighth Amendment to the Constitution was a brutal exclusionary provision in our constitutional text that took 35 years to, well, we're almost there in terms of removing it. But in terms of its gendered applications, its discriminatory applications, it was an exclusionary constitutional provision which denied women a right to equal citizenship in the state. It was introduced following the movement, the pro-life amendment campaign movement, which responded to concerns arising from the developments, particularly in the US, through courts and case law, Griswold and Connecticut on access to contraception, and Roe and Wade, of course, in relation to access to abortion as an aspect of the right to privacy. And we had our own McGee versus the Attorney General, which built on the idea of a right to have access to contraception as part of an aspect of a limited right to privacy, marital privacy only. But to try to stop that expanding right to privacy, the pro-life amendment campaign brought us the Eighth Amendment in 1983. And in doing so, appealed to a very conservative Catholic ethos that was deeply exclusionary and was based on an assumed homogeneity within the state, little or no recognition of difference. Abortion was represented as a violent colonial tool threatening the integrity of the Irish nation. And we saw that again in the course of the recent campaign in Ireland. The prohibition of abortion was almost absolute. The X case in 1992, a young woman aged 14, pregnant as a result of rape, had to battle all the way to the Supreme Court to vindicate her right to terminate her pregnancy and to demonstrate to the court that there was a real and substantial risk to her life arising from suicide. But those were the only exceptions, real and substantial risk to life, including a risk arising from suicide. We had many challenges to the Eighth Amendment, including challenges to the European Court of Human Rights, in what was a very poor judgment handed down from the court in 2010 in ABC versus Ireland. The European Court of Human Rights, by a majority decision, deferred to the Irish state, to the Irish government's argument that distinct moral sensibilities of the Irish people, which it was argued had not changed much since 1983, meant that a wide margin of appreciation should be given to the state in determining the balance of rights under Article 8 of the European Convention on Human Rights, which protects the right to private and family life. And the court agreed that a very wide margin of appreciation was due to the state because of those distinct moral sensibilities. And in the case of the first two applicants, A and B, who were arguing that they had a right to access to abortion as a part of their right to bodily autonomy and privacy protected under Article 8, the court said no, that the state had struck an appropriate balance and it was permissible to deny access to abortion, even in cases of risk to health and well-being, and to take account of socioeconomic circumstances. With regard to applicant C and Michelle Hart, who later died, they said no, the state had not provided her with effective access to what in fact should have been a lawful termination in the state. The European Court of Human Rights in particular emphasised that there was a possibility of travel for the first two applicants, A and B, that they could travel to the UK or elsewhere to vindicate their rights. And that in that context, the balance struck by the state was appropriate. So no account taken of the many barriers to travel that women and girls experience, whether it's due to poverty, restricted mobility, or immigration status. it is very unlikely, in my view, that such a line of reasoning would be acceptable in another type of human rights case. And very recently, just a few weeks ago, the UK Supreme Court, in handing down the judgment in a case taken by the Northern Irish Human Rights Commission, again trying to vindicate the right to have access to a safe and legal abortion for women in Northern Ireland, where abortion is also prohibited. The UK Supreme Court and Chief Justice Brenda Hale in particular commented that the margin of appreciation, the very wide margin of appreciation given to Ireland in the ABC case was highly unusual. And in particular, this reference to travel. Earlier in that case, in the Belfast High Court, Mr. Justice Horner had pointed out that restrictions on access to abortion bite on the impoverished but not the wealthy, that there was one law for the rich and another for the poor. And again, this has resonated in the Supreme Court, but unfortunately the Supreme Court didn't recognise the Northern Irish Human Rights Commission's standing to bring the case without a victim. It was an attempt by the Northern Irish Human Rights Commission to try to avoid a woman having to go through those proceedings and to test its possibility to stand in its own right. It was also very significant in that the human rights movement in Northern Ireland over several decades in the context of the conflict in Northern Ireland had often ignored questions around gender equality and women's rights, and reproductive rights had been put to one side and had not been part of the human rights canon of many civil society organisations working in Northern Ireland, including the statutory body, the Northern Irish Human Rights Commission. So that is a huge change that we're now seeing also in Northern Ireland. As we've heard already from Stephanie, of course, questions around reproductive justice also touch on questions around coercion and forced sterilisation. And here I just want to mention the case of VC versus Slovakia in the European Court of Human Rights, where the court found a violation of Article 3 of the European Convention on Human Rights, in particular with regard to forced sterilisation of a Roma woman in Slovakia, emphasising the interference with her reproductive health status and personal integrity, and the gross disregard to her right to autonomy, a word that we hear much of. They also emphasised the failure to respect her right to private and family life. But the court didn't find it necessary to adjudicate on Article 14, the discrimination claim. I think here there was a failure of the potential that could have come with an intersectional analysis. They didn't find that there was intention to discriminate or a policy of intentional discrimination. And a strong dissenting judgment is handed down by Judge Mitrovic, who pointed out that the findings on a violation of Article 3, prohibition of torture, inhuman and degrading treatment, and violations of Article 8, private and family life, while they were very significant findings, they reduced, in his view, the findings to an individual level. They didn't recognise the structural, systemic, intersectional nature of the discrimination that underpinned forced sterilisation. And that, I think, has been a problem with the jurisprudence of the European Court of Human Rights. It hasn't recognised those many connections across the different types of barriers that women and girls face. The Committee on the Rights of Persons with Disabilities has also addressed the question of forced sterilisation and emphasised an individual's right to decision making, that this should not be replaced by decisions of a third party. Again, the importance of autonomy, choice, legal capacity. And here it's also important to note in the European context the potential of the Council of Europe Convention on Violence Against Women and Domestic Violence, the Istanbul Convention, which is, I think, potentially a hugely radical document if implemented and interpreted broadly. But here the convention identifies forced sterilisation as a crime against women, and again highlights the the requirement of prior and informed consent. As Stephanie mentioned, the UN Committee on the Rights of People with Disabilities has taken a very particular view on the question of reproductive justice and has emphasised general provisions of the Convention, particularly as regards rights to equality and non-discrimination. Its concluding observations on the UK did raise some controversy in 2017. The committee recommended that the UK amend its abortion law, that women's rights to reproductive and sexual autonomy should be respected without legalising selective abortion on the ground of fetal deficiency. These points were also made by the CRPD committee in its submissions to the UN Human Rights Committee's discussions around the right to life and Article 6 of the Covenant on Civil and Political Rights. There is some crossover, but I would say limited, with the work of the CEDAW committee, the Committee on the Elimination of Discrimination Against Women, which has also criticised and highlighted the practice of sex-selective abortions and the persistence of deep-rooted stereotypes. In Ireland, Mallet versus Ireland was a significant decision of the UN Human Rights Committee, which again highlighted the stereotyping underlying Ireland's criminalisation of abortion. The stereotyping of women primarily as mothers, stereotyping Amanda Mallet in this case, as a reproductive instrument subjected to discrimination. And Amanda Mallet's case was followed on by Whelan versus Ireland, and both of those moments, very significant human rights moments, contributed to the human rights movement that has led to the repeal of the Eighth Amendment. And they concerned the situation of women pregnant following a diagnosis of fatal fetal impairment and the requirement to travel to the UK, the lack of dignity, privacy, and what the Human Rights Committee said was inhuman and degrading treatment faced by them, as well as discrimination. So critical to the movement in Ireland has been the question of autonomy. And although in the campaigning we emphasised togetherness, connectedness, in fact it was women's rights to choose that it seems was the most influential factor in people's decisions in voting. It was a movement that emphasised connections and intersectionality. Persons with disability experiencing inequality in many different ways, in accessing good health care, the risks of poverty, the potential of the ban to make experiences of inequality worse. Inclusion Ireland statements were particularly important in emphasising the values of dignity, autonomy and social justice. And now we're at the moment of thinking about reproductive justice, accessibility, affordability, equality, and I would say also the significance of care, empathy, thinking differently about rights, thinking about rights as relational, as based on an understanding of the human self as embedded in communities and networks and as embodied, rather than the isolated atomistic individual and that very impoverished understanding of autonomy that has prevailed in human rights thinking in the past, a much more relational understanding of autonomy. But we need now, at this so-called after rights moment, in this very risky period in Ireland's reform process, we need to think deeply about accessibility, access to information, outreach, travel. And we need to think about healthcare and effective access to healthcare. And we need to think more broadly around questions of sexuality and sexual violence, as we have been hearing all of this week. Privacy is helpful in thinking about reproductive justice, but we need to move beyond this kind of gendered line drawing and think about substantive equality and substantive equality outcomes. Good reproductive health. The report of the inquiry into the death of Savita Halappanavar here in Galway, the chair emphasised good reproductive health as being about public health. We need to think about the school curriculum, access to family planning and contraception, and facilitating of safe abortion care. Intersectionality, we think about access to reproductive justice not as a single issue, but one with many connections, as Audre Lorde reminded us. And to conclude, I'll just make a comment on intersectionality analysis. I was looking back at some of my own work in this field, which had been very much about migrant women coming to Ireland, the 2004 citizenship referendum, which removed the right to citizenship by birth in Ireland. People voted 4-1 in favour of that. A toxic racist discourse surrounded that referendum, and particularly a targeting of pregnant black women. An intersectionality analysis at the time, when I was reflecting on that, was helpful in terms of mapping multiple forms of discrimination, as Amita reminded us earlier this week. My own view was that it didn't take us further. It didn't provide us with the normative foundations to move forward, to think about disability and reproductive justice. I think now that maybe that was wrong. And I think if we think about intersectionality as very much about connectedness, and we think about the human rights movement that has just concluded in Ireland, that connectedness and that very different concept of the human self, and recognising the connections across many barriers, poverty, disability, race and ethnicity, and immigration status and gender, that can provide us with the foundations for thinking differently about justice and reproductive rights. Thank you.
Thank you, Siobhan, for that intervention. I think that countries that face the question of legislation, like Ireland at this moment of Ireland, is also key, because some of the ways in the opposition happens is by fragmenting. So I've seen already articles about Ireland of like, okay, pass it but exclude the disability exception in the new law, etc. Argentina just went through a legislative process that had very hard conversations, and actually productive ones, among the disability rights movement and the reproductive justice movement. So with that, I'd like to pass the mic to Emma Burns, who is a PhD candidate here at the Center for Disability Law and Policy.
The one behind it, Emma.
Oh, the one behind.
The one that has your name on it.
Can't see that far. Sorry.
There, look. Look at it here now. It's right in front of you.
Look at that.
There you are. No bother. There you are.
Lovely. Thank you.
Thank you. Okay, so my name's Emma Burns. I'm a PhD student here, and my topic is around the political participation of people with intellectual disabilities, but that's not why I'm talking to you here today. I'm here in my role, I suppose, as an activist, and my involvement in the referendum campaign. I still am, I suppose, we haven't disbanded quite yet, co-convener of the group Tipperary for Choice. It was a grassroots group established in 2014, and we wanted to campaign for access to abortion rights. It's a bit whiny. So for those of you who don't know Tipperary, or don't know Ireland very well, Tipperary is one of the 3 most conservative constituencies in the country. We did vote yes in the marriage referendum, and we really did not believe that we could achieve the same result in the abortion rights campaign. And I'm very happy to say that we were wrong. As we all were. So I'm not going to go through this because Siobhan gave you an overview of the Irish legal situation, but this timeline kind of gives some of points of interest to this discussion of disability rights and the abortion rights campaign. These cases, these letters, these numbers, they've become known as the alphabet of oppression. The high-profile cases that have pushed public conversation and public consciousness forward and that have ignited the grassroots activists to push for reform have predominantly concerned women and girls in precarious situations. So there's been a threat to their physical or their psychological well-being. They have been migrant women or women of colour. They've been children. They have been subject to violence or rape. They've been driven to psychological distress by the state. For the most part, these are not wealthy, middle-class Irish women. They are people without power or representation. They are people constrained by their status in society, by their circumstances, and these are the people who have fallen through the cracks. Grassroots organisations emerged to fill the gaps left by ineffective legislators and politicians who failed to promote human rights. There's long been resistance and protest in Ireland against restrictions on women's access to abortion, but it didn't truly catch fire until the death of Savita Halappanavar in 2012. She was a young Indian woman. She lived here in Galway. Her story resounded with ordinary people. Video footage emerged of her dancing just a few weeks previous to her death. She was young, she was beautiful, she was happy to be pregnant, and then it all went wrong. She suffered an inevitable miscarriage and she needed interventions, but because there was a fetal heartbeat, she received no aid. She was told that this was because Ireland is a Catholic country. She died of sepsis. There was a feeling that what happened to her could have happened to any of us. And people began to attend candlelit vigils for her. They began to talk and they began to organise. Around this time, the abortion rights campaign was formed, ARC. I will refer to it as ARC. As I said, other groups had been around long before this, so I'm not trying to take them out of this history, but ARC appeared at a crucial moment in history. There was anger and shame and momentum for change. ARC reached out to the small informal groups that had been organising around the country, and they built alliances and membership, and they offered facilitation and support. ARC was founded within an explicitly intersectional framing of abortion rights. This is from their own mission statement. So ARC aspires to be inclusive and representative of the varied groups of people affected by Ireland's restrictive abortion laws. We believe this requires a particular focus on those groups that are disproportionately affected by these laws, including women who are marginalised by poverty, racism, immigration status and disability. At this time, most of the focus around disability was on accessibility. It was on making the campaign accessible, meetings were being held in accessible venues, time was spent making documents accessible. No doubt some of the members themselves were women with disabilities. Disabled women were invited to speak at the annual march, and the march itself was made accessible. Outreach was happening, but it was slow. It was not until Susie Byrne spoke out in the press that she felt both sides in the debate were abusing people with disabilities that the work began to move beyond tokenism. This scared the life out of us. ARC wanted to start by co-authoring some myth-busting blog posts with women with disabilities to counter some of the ableist propaganda that was being put out. A private Google group was set up and women with disabilities were invited to come on board to liaise with ARC for the initial stages. We produced the blogs and they were useful enough, but they weren't enough. They didn't do enough to address the harmful discourse that was emerging around disability in the referendum campaign. Every mention of disability related to prenatal screening and children. Non-disabled pro-choice spokespersons often displayed ignorance of the concerns of women with disabilities, or worse, revealed embedded ableism in their framing of disability rights in the abortion rights campaign. Disabled women are often invisible as sexual citizens with intimate and personal relationships with families with the same potential to experience crisis pregnancies as non-disabled women. Disabled women as rights holders were largely missing from the debate for a long time. The group of disabled women that had come together to contribute to the ARC blogs decided that they would establish themselves as a distinct group, People with Disabilities for Repeal. This happened around the same time that Evie's group was established as well, and the work went on parallel. My own involvement with that group ended with their decision not to join ARC, and they've since gone on to form Disabled Women Ireland, and they've plans to continue and broaden their work. The input of these women was critical to reclaiming the discourse around the intersection between disability and abortion. At the same time, there were collaborations between ARC and groups like Merge, the Migrant and Ethnic Minorities for Reproductive Justice, with TENI, the Organisation for Trans Rights, with the Sex Workers Alliance, all with the aim of bringing those on the margins into the heart of the campaign. And then the referendum was announced for May 25th, and the three main groups, ARC, the National Women's Council of Ireland and the Coalition to Repeal the Eighth Amendment, they combined forces to create Together for Yes. This national campaign to repeal the Eighth Amendment. Siobhan hinted yesterday that this was a unified movement, a way for all the diverse groups to come together and combine efforts to secure abortion rights, and what success we had. Well, yes and no. I'm quite sure that the history books will record the referendum as having been won by politicians reaching across party divides and of communities seamlessly coming together, but it wasn't quite like that. There were tensions in the transition from being a purely grassroots, non-hierarchical, homegrown, diverse feminist organisation with transparent and shared decision-making processes into a slick, centrally managed, professionally run campaign with strict messaging and zero tolerance for deviation from the messaging book. I don't think we would have won the referendum without Together for Yes. I'm quite sure of that. It was necessary. But I also recognise that the damage was done to marginalised groups by the disengagement from the collaborative efforts that had informed the movement up until this point. The first thing to go was trans-inclusive language. The situation of trans men was pushed to the side. The term pregnant person disappeared from our campaign materials. Everything became about women and girls. Happily, yesterday, the Health Minister announced that trans-inclusive language will be used in the forthcoming legislation. So at least the voices were heard. I'm very glad that Susie and Evie have given largely positive reports about the referendum campaign, because from where I stood, it seemed that women with disabilities, migrant and ethnic minority women, and trans men were largely excluded from spokesperson roles and high-profile events, particularly in rural areas like where I was. The faces of the campaign were Irish and white. They were concerned, they were polite, they were professional. Each discussion panel that we held had to have a doctor, a lawyer, someone whose pregnancy had been affected by a fatal fetal abnormality. These were incredibly good advocates and activists, and I do not mean to disparage their efforts at all, but they were not representative of those women who we've named in the alphabet of oppression. For the most part, we didn't hear from the messier edges of the campaign, from the places where multiple oppressions occur to squeeze people of their rights. There was no place in this exceptionally respectable campaign for the sex worker, the woman with a psychosocial disability, women of colour, migrant women, traveller women, trans men. They were sacrificed for the greater good. Some groups rebelled and we held breakaway events that we did not tell HQ about, but for the most part there was a silent agreement that we would hold our tongues until the work was done. In a piece called Our Aims Are Shared, disability rights activist Maria Ní Flaherty pinpoints the commonalities between the position of pregnant women and of people with disabilities under Irish law. Pregnancy and disability are the two criteria which can remove a person's right to be the final decision maker in their own care. Pregnancy and disability can cause you to be treated without your consent. As Fiona said yesterday, we did not hear from people with psychosocial disabilities, despite their common experiences of forced treatment, removement of capacity, disregard for informed consent. Will we now have a broad campaign to reform psychiatric services? Equally, people with intellectual disability do not have their bodily autonomy respected. Some are given contraceptive injections without informed consent. Recently, it was ruled that an Irish woman with an intellectual disability was to undergo a mastectomy without her consent. Will we wear a badge for her? Single-issue campaigns can be harmful and damaging. We have learned that collaborative and direct action is required to create the pressure needed to push politicians into action. We've also learned the importance of narratives and of personal stories. These open people's minds to change. Those of us who campaigned by knocking on people's doors to ask for our rights learned also that the ordinary people, the people who are not engaged in politics or in activism, these people are not as conservative or as uninformed as we might imagine. Now, this might all sound a little bit negative and critical, but it's only by reflecting on the conflicts that we have in campaigns like this that we will identify how to improve our work. There were lots of successes. An early commitment to intersectionality gave us some very sound foundations. We built alliances across groups, we pledged loyalty to each other. The work is not done. As grassroots activists, we look to varying dimensions of intersectionality to inform our work on reproductive rights. It can help if we treat intersectionality in two ways. I'm referring to Patricia Hill Collins' work mostly here. First, as a form of critical inquiry that informs how we organise our analytical work. This is how we mostly use the term in academia and research. But the second is intersectionality as a form of critical praxis. So this is where we use the knowledge that we gain in everyday life, and we reflect on our experiences, and we aim to learn from formal knowledge, like research, like scholarly work. And where intersectionality is most potent is where we bring inquiry and praxis together. When we seek those connections and intersections common between us. But we can't do this without keeping sight of the power relations and the social structures which cause oppression. We can build strong civil society groups. We should build a plurality of groups so that each works in the ways and for the purpose that suit it best. The more groups, the better. We must always look for those points of intersection, find the commonalities, but also the shared points of attack, and combine efforts to dismantle the structures which contribute to oppression. The system that prevented access to abortion is the same system that violates the rights of people with disabilities. It is the same system that tolerates coerced treatment. It is the same system that confines people to direct provision. The work is not done. Ideas alone are not enough to move people to action, and action is more effective when it's informed by reflection and knowledge. The parts that worked well in this referendum campaign were the places where very, very different groups came together, and they listened to each other. The centre here made a submission to the Citizens' Assembly, which preceded the referendum, outlining how disability rights and abortion rights are not mutually exclusive. We did outreach to lawyers' groups. The lawyers' groups engaged with grassroots groups. We all informed each other. We must continuously reflect on ourselves, on our own practices. Are we reaching out? Are we sharing our knowledge? Are we learning from each other? Are we finding connections? What's stopping us? We must not be afraid to approach the other, to ask them to help. We must be willing to make mistakes. We must be willing to recognise that our own good intentions may be lousy with paternalism or stereotypical assumptions about the other. We must forgive those who make similar assumptions about us. And we must always, always be watchful for who is falling through the cracks. That's it. Thank you.
That was very inspiring, and I really hope that our colleagues in Ireland get to write the story of that journey for other groups in the world to learn from it, especially because usually successes of grassroots movements are claimed by the governors. So it would be great to have that story told to the rest of the world. So now I'm going to open the discussion. And if people who would like to ask questions could signal in some way, and I'll give you turns. So 1,